So no stay on the Citizenship Amendment Act by the Supreme Court of India. The Supreme Court of India today was hearing the petitions which have been filed against the CAA, the writ petitions challenging its constitutional validity. There are something like 144 petitions currently listed before the court. 142 of these are against the CAA, saying it violates Article 14. 2 of them are actually in support of it. Now, the court was today conducting a hearing after several weeks. The government was asked whether they'd filed their responses to these petitions. Notice had been issued on them in the previous hearing. The government said, look, we've only got around 60 of these petitions so far. There's more and more keeping on coming in, so we need more time to respond. The court has now given them 4 weeks to respond to all the petitions which have been received so far, and at that point the question will be taken up of whether this matter now gets referred to a larger bench or not, because only 3 judges have been hearing it so far, but because it involves matters of serious constitutional importance, it may need to go to 5 judges or more. But the 2 big things which came out of today's hearing were, first, that the court didn't grant a stay. Now, a request was made by Kapil Sibal and by other senior advocates representing the petitioners, where they said, look, even if you don't want to grant a stay, at least postpone the carrying out of any actions under the Citizenship Amendment Act. And importantly, not just the Citizenship Amendment Act, but the NPR process as well, which is scheduled to start in March-April 2020. Now, what's important about all of this is that they were saying, look, we understand you may not want to grant a stay, and the government obviously was opposing that, but they said, look, if you have processes under the Citizenship Amendment Act, like the naturalization process, because what it allows is a fast-track naturalization process for Hindus, Sikhs, Buddhists, Jains, Christians, Parsis from Afghanistan, Pakistan, Bangladesh. It said, at least don't, the lawyers were saying, at least don't allow that to start happening, because, and as Shyam Diwan pointed out, this could mean serious problems for those people, because say they give up their citizenship of Pakistan or Afghanistan or Bangladesh, and because they think they're going to get this fast-track citizenship, but then a few months down the line the court says, look, you know what, actually the CAA was unconstitutional, then these people will be at a disadvantage. Now, so and as Kapil Sibal pointed out, that once you've given someone citizenship, you can't sort of take it away. Now, on this basis, the court was hearing these arguments. The Attorney General contested, said this still amounts to a stay, and the court eventually decided they wouldn't agree with this, which is an interesting thing, because the request was only for it to be postponed by a few months. As was said, that, you know, look, the NRC and all these other issues which the CAA is tied to, these things haven't, or even the granting of citizenship on the CAA, they've not been done for 70 years. If it waits for another 2 months, nothing more would happen. But the court was not inclined to agree. The other big takeaway from today's hearings is that all the Assam cases, the cases dealing with challenges to the CAA from Assam, will be heard separately. Now, this is because there are special provisions for citizenship for Assam under the Citizenship Amendment Act, which were brought in because of the Assam Accords, Section 6A, and the whole regime of citizenship there is separate. At the request of certain petitioners, the court agreed that they would tag Assam and Tripura matters, because even Tripura has a special accord under which citizenship comes through. So as a result, those matters, those challenges from Assam and Tripura are going to be heard separately, not with the main petitions sort of arguing in general why the Citizenship Amendment Act is unconstitutional. That's the big takeaways. Obviously, as we said, within 4 weeks, government has to respond to all the petitions now. And it should be noted that while the court has not granted a stay at this point of time, they will consider the question of interim relief again when the case is heard next. Now, that's going to be after at least 4 weeks, so we're looking at around a 5-week period, so probably the end of February. At that stage, the court may consider whether or not it should grant interim relief as requested by Diwan and Sibal and others in terms of postponement. But as of now, at this point, there is no such delay granted. That request, obviously, because it deals with things going forward as well, may not necessarily be massively impacted. But of course, any naturalization process which starts during the next month could potentially be impacted by the failure to grant a stay or a postponement as requested by the petition. The court has said that they will take up certain small matters in the chambers, whether if it's either a question of immediate urgency, as well as to sort of decide how to sort of categorize all these cases and classify all these petitions which have been filed before them. Important to note that the Kerala petition, which was filed by the state of Kerala under Article 131 against the CAA, is not part of this set of petitions as of now, because that is obviously a different thing. It's not a writ petition, it's filed by a state claiming to have a problem with the centre. So that's it from the Supreme Court. We will keep giving you all the updates as and when we get more information about the responses of the centre and what's happening with these cases. Stay tuned to the Quint for all the updates.